In this lesson, what I want to do is talk a little bit more about this reasonable person standard. And we will talk about the circumstances, or at least some of the circumstances, in which this reasonable person standard is actually adjusted. Now, we noted in the previous lesson that the courts have been consistently reluctant to adjust this reasonable person standard to a higher or lower amount, specifically and especially to a lower level, owing to the fact that for the most part, the reasonable person test is an objective test and is a test that is supposed to be as objective as possible and not supposed to be determinate on the basis of individual cases and the facts of individual cases. But it is not always the case that the courts are reluctant to simply keep, or at least reluctant to adjust the standard lower. And this is what this lesson is going to be about. It's going to be talking about circumstances where we talk about the exceptions to the basic reasonable person standard. And by exceptions, I mean circumstances in which the standard is lowered. The most pertinent of this relates to children as defendants. So what about circumstances where the defendant in question is a child? Let's say they're 13 years old. Should we apply the reasonable standard of a reasonable man or a reasonable woman of adult age to that of a 13-year-old child, and so suggest that basically in any circumstance they would be found to have been liable in tort because children, for the most part, probably do not act in a way or in accordance with that of a reasonable person. Or at least it should be assumed that that is going to be the case in a lot of circumstances. Well, it has been held in cases that are subsequent to that of Nettleship and Weston that when we talk about the standard of care as applied to that of children, when we think about and add children to the mixture, essentially what we have to think about is whether or not this ought to adjust the standard and maybe lower the standard slightly. So where the issue relates to a child defendant, the conclusion that the courts have come to is that the reasonable person test should be adjusted to that of not just a reasonable person, but the reasonable person of the age of the child in question. So we essentially adjust the standard. So if we were thinking, like I said earlier on, to the idea of a 13-year-old maybe potentially being a defendant in a tort case, the standard is therefore adjusted to that of a reasonable 13-year-old. So what would a reasonable 13-year-old have done in the circumstances? This is seen as a more just solution to the concept of adjusting these standards and making an exception to the standard of care in order to essentially allow for a defendant who is a child to have a fair hearing in terms of their decisions to act in a particular circumstance. Because for the most part, owing to brain development and maturity and all these different factors, children probably do not act in circumstances which are of the standard of a reasonable adult. And so the result of that means that they would have to adjust this standard slightly. But the resulting adjustment of standard means that essentially we allow for a more just settlement for children. But the reasonable standard of care for children is still not entirely as simple as this, okay? And we'll talk about the case of Mullen and Richards in a second, but ultimately, the courts have been asked the question of the reasonable standard of children, and they've been told that they've said essentially that we will adjust it to the reasonable age of the child in question. But what does that actually look like in terms of a shift in the standard? Does that actually significantly lower the standard in any meaningful way? Well, the ultimate conclusion here is that when we think about the reasonable standard as applied to children, the closer the age of the child gets to the age of majority, the less of an impact that this adjustment will actually have. If we're talking about a reasonable 13-year-old, then we could probably expect that the standard of care is adjusted quite significantly and quite significantly lower to account for the fact that we're talking about the reasonable standard of a 13-year-old. But what about somebody who's 17 or 16? Well, it is held that, essentially, the closer we get to the age of majority, the closer we get to an 18-year-old, the more the standard of care of a 17-year-old, for example, or the reasonable person who is 17, will just look like the standard of care for a basic adult. So the closer and closer that we get to the age of majority, the less and less of an impact that this exception will actually have, and the less and less of an adjustment this will actually be. So let's think about this in reference to the case of Mullin and Richards from 1998. In this case, both the defendant and the claimant had been schoolgirls who had been playing with plastic rulers and had pretended to have a sword fight with the plastic rulers. One of the bits of plastic would actually break in the course of having this fight, and a sharp fragment of plastic had gone into the claimant's eyes, blinding her in one eye. So quite a horrific incident that had taken place. Now, we all know, if we've all remember being at school, knowing that those plastic rulers aren't particularly sturdy, so something like this would have happened, is likely to have happened reasonably. When the question of negligence arose, the question of whether or not the defendant, in this case the other schoolgirl, who had ultimately acted in a way that may have caused the sharp fragment to have gone in the claimant's eyes, the issue immediately turned to the issue of the standard of care. It became one of apparent importance. The two girls were 15 years old, and so the question was, should the standard of care be that of a reasonable person, i.e. a reasonable adult who was acting in this circumstance, or should it be the standard of care of a 15-year-old, a reasonable person who was 15 years of age? The courts held that, where it came to issues relating to that of children, the reasonable person standard ought to be adjusted to essentially account for the fact that these people are younger than the age of 18, and they are not adults yet. And so as a result of which, the reasonable person is probably the reasonable person of the age of the defendant. So the reasonable person is a reasonable 15-year-old rather than a reasonable 25-year-old or reasonable adult. Maybe an adult acting in this circumstance would have acted in a way and reasonably have foreseen that this kind of damage or injury could have occurred. But would a reasonable 15-year-old have had that same foresight in terms of their actions? Potentially not. And so the result of this means that we adjust the standard of care slightly lower. So the standard of care was not judged in this case to be the standard of an adult, a reasonable adult, but in fact a reasonable 15-year-old. So essentially, that's what the standard of care as applied to children essentially represents. And as I mentioned earlier on, the adjusting of the standard will be on the basis of the age of the child, but the closer that we get to the age of majority, the more that it will reflect that of just a reasonable adult. So somebody who is 17, for example, there's probably no difference in terms of the standard of care for a reasonable 17-year-old versus a reasonable adult, a reasonable 18 or 19-year-old. There tends to be no difference in those regards. It's only in the circumstances where we're talking about quite significant age distinctions, so things like 13 or 12 or 15 or 14 in these cases, where we start to think, well, these people are probably very different and will act in a very different way to that of 20 or 23-year-olds, for example. So, like I said, when a defendant is, for example, 13, the reasonable standard would probably look quite different to that of if they were just an adult. But if they were 17, while they're still not an adult, the reasonable standard would probably on its face be that of an adult. It will look very similar to that of an adult, given the fact that there is very little delineation that one can reasonably make between that of a 17-year-old and that of an 18-year-old.